In this lecture, we would like to discuss about states reorganization, and that is falling under union and its territories under Article 1 to Article 4 of the Constitution. So, what exactly Article 1 of the Constitution expresses that India, that is, Bharat, shall be a union of states, and it found under Fazal, and in that connection we found it is an indestructible union composed of destructible states. So it contains those states, union territories acquired by the government of India. And Section 3 and subsection 2 of the Territorial Waters Continental Shelf Exclusive Economic Zone and Other Maritime Zones Act 1976 provides 12 nautical miles from the baseline under the 40th Amendment raised a distance up to 200 nautical miles from the baseline. So, in this regard, we would like to exactly what the provision in this connection provided that the state and union territories, and in that regard, we could say at present, after the state reorganization, the very recommendations under the State Reorganization Act 1956 by creating 14 centrally governed states and 6 union territories. So, the very provision regarding state reorganization that we would like to discuss, and before that, we would like to discuss the very background or historical background. And if you would like to discuss the very historical background before independence on the basis of linguistic and cultural base, the first such state in India during that period was created by the Britishers, and that was Odisha, which was formed as a separate state by carving out from the Madras Presidency and from the Bengal Presidency, and it was formed on 1st April 1936. And after independence, the states in India were divided into 4 divisions such as Part A, Part B, Part C, and Part D. Under Part A, there were 9 states such as Assam, West Bengal, Bihar, Bombay, Madhya Pradesh, which was formerly known as Central Provinces, and Bihar, Madras, Odisha, Punjab, and Uttar Pradesh, formerly United Provinces. These states were primarily based on historical reasons and shared cultural and linguistic ties. And the Part B states are also 9 states comprising Hyderabad, Jammu and Kashmir, Saurashtra, Mysore, Travancore, Cochin, Madhya Bharat, Vindhya Pradesh, Patiala, and East Punjab states union. These states had unique characteristics and were formed considering local identities. And Part C, and that is also constituting 10 states at that time, included Delhi. Kutch, Himachal Pradesh, Bilaspur, Cook, Bhopal, Manipur, Ajmer, Kusvihar, and Tripura. These states were a mix of former chief commissioners, provinces, and centrally administered areas. And Part D, which was constituting the Andaman and Nicobar Islands, were governed by an appointed governor under the Indian president. So, the very rationale behind reorganization of Indian states, which was started with the appointment of the Said Fazal Ali Commission in 1952, which particularly related to formation and establishment of 16 states and 3 centrally administered territories. But finally, it was led to creation of 14 centrally governed states and 6 union territories, which led the passing of the 7th Constitutional Amendment Act in 1956, which replaced the 4 different divisions of states as such: Part A, Part B, Part C, and Part D. And finally, it recommended only 2 categories of states and union territories. So the states were created after the recommendation of the Said Fazal Ali Commission and after the passing of the State Reorganization Act of 1956. Those states were Andhra Pradesh, Assam, Bihar, Bombay, Jammu and Kashmir, Kerala, Madhya Pradesh, Madras, Mysore, Odisha, Punjab, Rajasthan, Uttar Pradesh, and West Bengal. And those union territories were Andaman and Nicobar Island, Delhi, Himachal Pradesh, Lakshadweep, Meenakoi and Amitabh Islands, Manipur and Tripura. And in that connection, we would like to discuss the very formation of the states as per the recommendation of the Said Fazal Ali Commission, who submitted reports in 1955 and ultimately State Reorganization Act of 1956 was enacted. And before that, Andhra Pradesh as a state was constituted in 1953 and Kerala as a state in 1956. So, Bombay Reorganization Act of 1960, which carved out 2 states such as Maharashtra and Gujarat, and the Punjab Reorganization Act of 1966 carved out Punjab and Haryana, and the state of Nagaland Act 1962 created the new state of Nagaland, and the Mysore State Act of 1973 changed Mysore to Karnataka, and the Madras State Act 1968, which made Madras to Tamil Nadu, and the very elevation of union territories to the status of state. So, in 1970, Himachal Pradesh was elevated to a state from Union Territory status, and Manipur, Tripura, and Meghalaya were elaborated as states from the Union Territory status in 1971. Mizoram and Arunachal Pradesh were elevated to the status of state in 1986, and Goa, which was a union territory, was elevated to the status of a state in 1987. And in 2000, the Jharkhand, Chhattisgarh, and Uttarakhand states were created. And finally, the Andhra Pradesh Reorganization Act 2014 created on 2nd June 2014 the Telengana states. So, in that connection, we would like to discuss the very union territories that at present the Andaman Nicobar Island, Lakshadweep, Dadra and Nagar Haveli, Daman and Diu, Pondicherry, Chandigarh, and the National Capital Territory of Delhi. So, now we would like to discuss the very territories acquired. So, Puducherry, which was a colony of France since 1954 up to 1962, became a part of India and was given the status of an union territory. So the Portuguese enclaves of Goa, Daman and Diu, and Dadra Nagar Haveli were acquired by India and given the status of union territory in 1962. And in that connection, we would like to discuss one decision of the Supreme Court in 1981 in the leading case Vinod Kumar versus Gangadhar, where the apex court expressed that on acquisition of territory, the pre-acquisition laws and the rights acquired may continue only if the new command chooses to recognize them unequivocally. So, also, in regards to the provisions of the Constitution, in regards to Union and its territories, under Article 2, the Parliament has the supreme power in regarding admission and establishment of new states. And in that connection, we would like to discuss the position of Sikkim. And Sikkim, an Indian state during the British rule, it was under the royal family of Chogyals, and the Government of Sikkim Act of 1974 put an end to monarchy in Sikkim and decided to join the Indian Union. So, in furtherance of that, the 35th Constitutional Amendment made it an associate state of India. And finally, under the 36th Amendment Act, it became the 22nd state of India. So, now we would like to discuss some other important rationales or the logic behind reorganization. So, when the Said Fazal Ali Commission established in 1952 and it submitted its report in 1955, it was considering the reorganization of states, which involved balancing administrative, cultural, economic, and political factors. It was aiming to create a responsible and inclusive framework for governing India's diverse regions. So, one of the logic before the commission was on the basis of linguistic and cultural affiliations. So the reorganization often took into account the linguistic and cultural similarities among people in a particular region. That was the help for better administration and governance. So, after independence, the first linguistic state created and which was carved out from Madras was Andhra Pradesh in 1953. And also certain regions in India like the Bodoland in Assam and the tribal areas in Tripura have been demanding separate statehood to preserve their unique cultural identity and for better economic development. And some other logic behind state reorganization could be tribal and ethnic identities. So states like Nagaland were formed considering tribal affiliations, and this was done to address the unique cultural and social aspirations of specific communities. And sometimes economic development become a logic behind reorganization. So some regions like Chhattisgarh, Jharkhand felt that separate statehood was necessary for economic growth as the existing state government was unable to adequately meet the development needs of the area. An important issue. So, these are the logic behind the creation of new states. So, in that connection, Kerala was formed in 1956 under the State Reorganization Act. The new state of Kerala was established by merging Travancore Cochin with the Malabar district, which was previously part of Madras state. And in the same way, as already we have discussed, Maharashtra and Gujarat were carved out under the Bombay Reorganization Act of 1960. This resulted from agitations like this. Samyukta Maharashtra movement, also Punjab, Haryana, and Himachal Pradesh were carved out in 1966 under the Punjab Reorganization Act of 1966, which led to the creation of Punjab for Sikhs and Punjabi speakers, and Haryana for Hindi speakers, and Himachal Pradesh for hilly terrain, and Chandigarh remained as a union territory. So, comprising all these states, India at present is consisting 28 states and 8 union territories. So, after the formation of Telengana on 2nd June 2014, the last reorganization of states was made in 2019, and that is relating to Jammu and Kashmir and Ladakh. So the former state of Jammu and Kashmir was divided into two separate union territories. So, in that connection, would like to discuss certain important leading cases as such relating to acquisition of foreign territories. So, in a particular decision, which is the most important landmark case, and that is Berubari Union case of 1960, where the apex court expressed that Article 1 does not confer power to acquire foreign territories. And also, we would like to discuss another important leading case, that is Harivansh versus State of Maharashtra. In 1971, the Supreme Court expressed that foreign territories which became part of India on acquisition may either be admitted into the Union or constituted into new states under Article 2 and or emerged into an existing state under Article 3, Clause A or Clause B, or formed into a union territory. Of course, a foreign territory would not come under Article 1, Clause 3, Subclause C until there is legal transfer of territory to India so as to constitute its acquisition in international law, as it was expressed by the apex court in 1971 in this leading case, Harivansh versus State of Maharashtra. And now we would like to discuss another important judgment of the apex court relating to permanent residents of Jammu and Kashmir. In the leading case, State Bank of India versus Santosh Gupta in 2017, it was held that permanent residents of Jammu and Kashmir are citizens of India. And now we would like to discuss another important judgment relating to the boundaries of a state. So, territories of a state as an commencement of the Constitution on 26th January 1950 was not frozen, and the Constitution provided for prospective changes including alteration of boundaries as it was expressed by their lordship of the Supreme Court in Ram Badan Rai versus Union of India in 1999. So, in that connection, we would like to discuss certain other features in relating to the territory of India. So, what does exactly means the territory of India? And it was also pronounced by the apex court in a 1962 judgment in the leading case, that is N. Mastan Sahib versus Chief Commissioner Pondicherry. The term territory of India has been used in several articles of the Constitution, and in every article where this phraseology is employed, it means to the territory of India for the time being as falls within Article 1, Clause 3. But the very phrase cannot mean different territories in different articles. And also, in the question relating to territorial waters, Section 3, Subsection 2 of the Territorial Waters, Continental Shelf, Exclusive Economic Zone, and other Maritime Zones Act 1976 now provides that the limit of territorial waters is the line every point of which is at a distance of 12 nautical miles from the nearest point of the appropriate baseline. Another notification of the command dated 15th January 1977 has extended the exclusive economic zone of India up to a distance of 200 nautical miles into the sea from the shore baseline. This has been done under the territorial waters continental shelf, exclusive economic zone and other Maritime Zones Act 1976 passed after the Constitution 40th Amendment Act 1976. So the very expression territory of India, wherever used, means the territory which for the time being falls within Article 1, Clause 3. So, the provisions of Article 2, which relates to admission or establishment of new state, the complete forward or in regards to that, under the Constitution, is provided to the Parliament or to the Union. So, in that connection, we could like to discuss the very power to admit new states into the Union under Article 2 is no doubt in the very nature of the power, very wide, and its exercise necessarily guided by political issues of considerable complexity, many of which may not be judicially manageable, as it was pronounced by the Supreme Court in one important judgment, and that is R.C. Pudiyal versus Union of India in 1993, and in regards to formation of new states. The Apex Court expressed in another important leading case, Mangal Singh versus Union of India in 1967, that the power with which Parliament is invested by Article 2 is power to admit, establish, or form new states which conform to democratic pattern envisaged by constitutional power which Parliament can exercise under Article 4 is supplemental, incidental, or consequential to the admission, establishment, or formation of state contemplated by the Constitution as it was expressed by the Apex Court. So, as per the provisions of Article 3, the Parliament of the Union has the power regarding alteration of areas, boundaries, or names of existing states. So, the very article provides that Parliament may by law form a new state by separation of territory from any state or by uniting two or more states or parts of state or by uniting any territory to be part of any state, under which we could cite the example creation of Maharashtra and Gujarat, also Punjab, Haryana, Himachal Pradesh, and Chandigarh, also the creation of Kerala, and also Jharkhand, Chhattisgarh, Uttarakhand, and even the newly formed state in 2014, the state of Telengana. It also, Parliament has the power to increase the areas of any state, and it can also diminish the area of any state. Even it can alter the boundaries of any state, and it could also alter the name of any state. So, in that way, many states were renamed, and some union territories also were renamed under the very provisions of this particular Article 3 of the Constitution, as we found in the change of name, such as from Madras to Tamil Nadu, and the very name changed in case of Puducherry, and also certain states which were renamed under these very provisions of Article 3 of the Constitution. And in that regard, we would like to discuss some other provisions like the lease agreement in perpetuity of some areas at Tinbiga, Indian territory, to Bangladesh did not amount to lease or surrender of sovereignty. It amounts to servitude suffered by India as it was decided by the apex court in the leading case, Union of India versus Sukumar Sengupta. And the next one important article, that is Article 4 relating to Union and its territory, which particularly provided that laws made under Article 2 and 3 of this Constitution to provide for amendment of the first and the fourth schedule and supplemental, incidental, and consequential matters. So, these are the provisions under Article 1 to Article 4 of the Constitution of India, which clearly indicates the power of state reorganization, change and alter in the boundaries and name of any state, and all connecting to state reorganization are constitutionally provided under Article 1 to Article 4 to the Union or the Union Parliament. And in that connection, we have discussed some major judgments and landmark judgments relating to state reorganization and the State Reorganization Act of 1956, and also the historical background that was relating to the division of states, like Part 1, Part B, Part A, Part C, and Part D. And consequently, after the adoption of the State Reorganization Act 1956, states in India were divided into two categories, states and union territories, and at present we have recently in 2019 the state of Jammu Kashmir was divided into two union territories as such. The union territories of Jammu and Kashmir and the union territories of Ladakh. And in that connection, we have discussed the presidential order of 2019 in our previous lecture while discussing about Article 370 of the Constitution. So, in this particular lecture, also we have dealt with what exactly territory of India and how it was interpreted by the apex court in several decisions, and also the very provisions relating to territorial waters, and as it is provided under the territorial waters and in particularly continental self-exclusive economic zone and other maritime zones act 1976, and which was passed after the 40th constitutional amendment act of 1976.